How deposits work in commercial real estate leases. If you're negotiating a commercial real estate lease, whether for retail space, an office, or an industrial warehouse, one of the first financial commitments you'll encounter is the lease deposit. Unlike residential leases, where deposits are often heavily restricted by local tenancy laws, commercial lease deposits are largely driven by contract law and commercial negotiation. Essentially, a commercial lease deposit serves two primary functions. It demonstrates the tenant's financial intent, and it provides the landlord with security against potential defaults or obligations down the line. But how it's structured, applied, and held can vary significantly. First, it's critical to understand that a commercial deposit is rarely just a flat sum. It usually consists of two distinct components. Advance rent. Landlords commonly require the first month's rent and either the last or two last months' rent upfront. Advance rent is directly applied to specific rental periods once the lease commences. Security deposit. This is a separate pool of funds held by the landlord throughout the term of the lease. Its job is to protect the landlord if the tenant defaults on rent, damages the premises beyond normal wear and tear, or fails to satisfy restoration obligations at the end of the term. In many deals, these are combined into a single initial payment during the execution of the offer to lease or letter of intent. So how much should you expect to put down? There is no standard statutory limit. The total deposit amount is heavily influenced by the tenant's creditworthiness, the financial standing of the business, and whether the landlord is funding custom tenant improvements, often called a tenant improvement allowance. For an established business, a deposit might simply equal 1 or 2 months of gross rent, which includes base rent plus estimated operating costs. For a startup or higher risk tenant, a landlord might demand 3 to 6 months or even more. Where does the money go? Upon signing the letter of intent or formal lease agreement, the deposit is typically transferred to the landlord's real estate brokerage or legal counsel to be held in a trust account or escrow until the lease commencement date. At that point, the funds are distributed according to the agreement. Advance rent gets applied, and the security deposit is retained by the landlord. What happens to that security deposit when problems arise or the lease concludes? During the term, if a default occurs, the landlord typically holds the contractual right to draw down on the deposit to cover unpaid rent or cure breaches. The lease will usually compel the tenant to immediately top the deposit back up. If no default occurs, the deposit is meant to be returned at the end of the term. But getting that money back is where significant legal friction frequently occurs. Unlike residential leases with mandatory return timelines and government oversight bodies, commercial deposit recovery relies almost entirely on civil contract enforcement. Common legal challenges include disputed restoration costs. Landlords often apply the deposit toward restoration or make-good provisions, claiming the space wasn't returned to its original state, leading to costly disputes over what constitutes reasonable wear and tear versus actionable damage. Unilateral set-offs. Landlords may offset the deposit against alleged operational adjustments, utility reconciliations, or legal fees, effectively holding the funds hostage while forcing the burden of proof back onto the tenant. Commingling and insolvency. In many jurisdictions, unless explicitly required by the contract, landlords are not mandated to segregate deposit funds into designated trust accounts. If the landlord faces financial distress, insolvency, or sells the property without proper assignment covenants, retrieving the deposit becomes a complex, high-risk legal battle. To summarize, commercial lease deposits aren't just simply put down payments. They are structured risk management tools that tie up capital and set the operational tone for the landlord-tenant relationship. Always ensure the exact terms governing deposit application, holding conditions, and return mechanisms are clearly defined in both their preliminary offer and the final lease agreement before transferring any funds. Meanwhile, to learn more about our law firm's commercial leasing legal practice, we welcome you to visit our website and contact our law firm to schedule a consultation. Thank you.